This video is made for educational purposes only and cannot be taken as legal advice. In this video we are going to take a look at willful obstruction of a police officer and common law. Rice vs. Connolly.
Queen's Bench Division, 1966. Hearing dates: 3 May 1966.
The appellant was seen by police officers in the early hours of the morning behaving suspiciously in an area where on the same night breaking offenses had taken place. On being questioned, he refused to say where he was going or where he had come from. He refused to give his full name and address, though he did give a name and the name of a road, which were not untrue. He refused to accompany the police to a police box for identification purposes, saying, "If you want me, you will have to arrest me." He was arrested and charged with willfully obstructing the police contrary to Section 51(3) of the Act of 1964.
On appeal, it was conceded that willfully imported something done without lawful excuse.
Section 51(3), so far as material, provides, any person who willfully obstructs a constable in the execution of his duty shall be guilty of an offense. Held, although every citizen had a moral or social duty to assist the police, there was no relevant legal duty to that effect in the circumstances of the present case. And the appellant had been entitled to decline to answer the questions put to him and, prior to his arrest, to accompany the police officer on request to the police box to establish identity, accordingly. In the circumstances, willful obstruction by the appellant was not established, although he had been obstructive, because no obstruction without lawful excuse had been established. CP 652, letters D and I post. Meaning of obstruction, stated in Hinchcliffe v. Shelton, 1955. Lord James, J. I would not go so far as to say that there may not be circumstances in which the manner of a person, together with his silence, could amount to an obstruction of the police within Section 51(3) of the Police Act, 1964. There is real distinction between a case where there is merely a refusal to answer questions and a case where false information is given. As to obstructing the police in the execution of the duty, see 10 Halsbury's Laws, 3rd edition. As to a constable's right to assistance from private persons, see 30 Halsbury's Laws, 3rd edition. Judgment 1. Lord Parker, C.J., in the early hours of the morning N1 of March 8, 1965, Police Constable Bailey was out on patrol duty on his pedal cycle in and around Oxford Street, Grimsby. A number of breaking offences had been committed that night, and the officer was looking out to see if he could see anyone behaving suspiciously. One indeed of these breakings had been committed quite close to where he was within the previous 45 minutes. He saw a man who turned out to be the appellant behaving suspiciously, looking into shop windows, looking round, seeing the constable and moving up a side street. Coming back later from the side street and going along looking at further shops, and keeping a wary eye on the constable. A time came when Police Constable Bailey, who had by then been joined by another police constable, went up and stopped the appellant. Police Constable Bailey asked where he was going, and the appellant ignored the inquiry, though he heard it.
The police constable again asked him where he was going and where he had come from and for his name and address, whereupon the appellant replied, "Give me a good reason why I should." In due course the appellant was allowed to walk away, and when he had got a little distance away he stopped to light his pipe. The police officers then saw that he had got a cut on his finger. They went up to him again, and again Police Constable Bailey asked for his name and address. After again being asked a second time, he merely replied, "Rice, Convermore Road." That incidentally was true as far as it went. The police constable said that he wanted his full name and address, and the appellant refused to give it. Finally the police constable asked the appellant to accompany him to a police box to confirm his identity, whereupon the appellant replied, "Look, son, I am not moving from this spot. If you want me you will have to arrest me."
Thereupon the police constable arrested him and gave as the ground for arrest that he had obstructed him in the execution of his duty in that he refused to say where he was going, where he had come from, and had refused to give his full name and address, and had refused to accompany him to the police box. Those were the facts as found by the recorder, with these additions, that throughout the appellant's manner had been sarcastic and awkward, that when, long after the arrest, he was seen by an inspector, the appellant said, "I have been arrested. You cannot arrest me. It might be worth a bob or two to me. I've done nothing wrong. I am arrested, what are you going to do?" Lastly, it is found that in fact the appellant never was charged with any of the breaking offenses in the neighborhood. Nor were there ever any grounds for suspecting that he was guilty of any of them. It was in those circumstances that the recorder expressed his decision in these terms: "I was of the opinion that on the facts as stated above and having regard to those set out in para. 5 VII, i.e. the remarks made after arrest to the inspector, the appellant had deliberately intended to distract Police Constable Bailey from his duties and had thereby willfully obstructed Police Constable Bailey in the due execution of his duty and was guilty of the offense charged. I therefore dismiss the appeal. The question left for the opinion of the court is whether the recorder was right in finding that the conduct of the appellant on the facts stated amounted to a willful obstruction of the police constable in the due execution of his duty. The statute creating the alleged offense in this case is S. 51(3) of the Police Act 1964. Which increases the penalties for assaults on police constables and obstruction of them in the execution of the duty, but otherwise preserves largely as offences those which appeared in earlier legislation N2.
What the prosecution have to prove is that there was an obstruction of a constable, that the constable was at the time acting in the execution of his duty,
and that the person obstructing did so willfully. To carry the matter a little further, it is in my view clear that to obstruct in S. 51(3) is to do any act which makes it more difficult for the police to carry out the duty. That description of obstructing I take from the case of Hinchcliffe vs. Sheldon N3. It is also in my judgment clear that it is part of the obligations and duties of a police constable to take all steps which appear to him necessary for keeping the peace, for preventing crime or for protecting property from criminal injury. There is no exhaustive definition of the powers and obligations of the police, but they are at least those, and they would further include the duty to detect crime and to bring an offender to justice. It is quite clear that the appellant was making it more difficult for the police to carry out the duties, and that the police at the time and throughout were acting in accordance with the duties. The only remaining element of the alleged offense, and the one on which in my judgment this case depends, is whether the obstructing of which the appellant was guilty was a willful obstruction. Willful, in this context in my judgment means not only intentional, but also connotes something which is done without lawful excuse, and that indeed is conceded by counsel who appears for the prosecution in this case.
Accordingly, the sole question here is whether the appellant had a lawful excuse for refusing to answer the questions put to him.
In my judgment he had. It seems to me quite clear that though every citizen has a moral duty or, if you like, a social duty to assist the police, there is no legal duty to that effect. And indeed the whole basis of the common law is that right of the individual to refuse to answer questions put to him by persons in authority, and a refusal to accompany those in authority to any particular place, short, of course, of arrest. Counsel for the respondent has pointed out that it is undoubtedly an obstruction, and has been so held, for a person questioned by the police to tell a cock-and-bull story, to put the police off by giving them false information, and I think he would say, well, what is the real distinction? It is very little away from giving false information to giving no information at all. If that does in fact make it more difficult for the police to carry out the duties, then there is a willful obstruction. In my judgment, there is all the difference in the world between deliberately telling a false story, something which no viewer citizen has a right to do, and preserving silence or refusing to answer, something which he has every right to do. Accordingly, in my judgment, looked on in that perfectly general way, It was not shown that the refusal of the appellant to answer the questions or to accompany the police officer in the first instance to the police box was an obstruction without lawful excuse. I would add this, that for my part one have very grave doubt whether the recorder was approaching the case on that basis.
I think that the recorder had in mind that though the appellant had a perfect right to refuse to answer questions, his whole conduct in this instance and the answers he did give were such as to be a deliberate obstruction to the police.
I say that for this reason, that he went out of his way to find that the appellant's manner throughout was sarcastic and awkward. He went on to recite that extraordinary attitude taken up by the appellant after arrest, in the conversation with the police inspector. And finally he said in his opinion that the appellant had deliberately intended to distract Police Constable Bailey from his duties. I cannot help feeling that the recorder here was giving full effect to the law as I understand it to be, but also was saying that the appellant's whole attitude and behavior amounted to a distraction of the police constable from his duties. However, there are certain difficulties in this in that neither counsel before us today has suggested that that is the true view of the recorder's decision in this case. And indeed counsel for the respondent has invited us to deal with the matter on a more general basis. Finally, I do see myself having difficulties in upholding the recorder's decision on that ground, if that be the true ground of his decision. In the first place, it would require conduct going further than what happened in this case to establish an obstruction, and secondly, one of the matters, and apparently an important matter in the recorder's view, was the appellant's behavior after his arrest, in front of the inspector. This was something long after the event, which could not be evidence of the awkward behavior, if it was awkward,
of the appellant at the time of the incident itself.
In these circumstances I have come to the conclusion that this appeal succeeds. Judgment 2, Marshall, J. I agree. In order to uphold this conviction, it appears to me that one has to assent to the proposition that where a citizen is acting merely within his legal rights, he is thereby committing a criminal offense. I cannot see that the manner in which he does it can make any difference whatsoever, and for the reasons given by Lord Parker, C.J., I agree that this appeal should be allowed. James J. Judgment 3, James J. For the reasons given by Lord Parker, C.J., I also agree that this appeal should be allowed. For my own part, one would only add this, that I would not go so far as to say that there may not be circumstances in which the manner of a person together with his silence could amount to an obstruction within the section. Whether they do remains to be decided in any case that happens hereafter, not in this case, in which it has not been argued. Disposition, appeal allowed. Conviction quashed.